Well, good afternoon, and I apologise for the delay, but the computer decided to exercise their right to disconnect, I think. Is that the best way to put it?
Zinger.
Zinger, that's a zinger. That's a good way to start. Jules, we've got an immense amount of content to get through today.
Massive.
We're going to try our best. I suspect that we'll get a little bogged down in some things, and we might have to speed through a few others. I don't want people to be worried about that. I think we'll probably bring some of these topics back individually in the coming months, because I think some of them warrant that. And I should also say that while we're here to talk about the legislation that gained royal assent yesterday, great timing for the webcast.
Suspiciously good
timing for the webcast. Interesting enough, some of the things that have happened are actually amendments of the changes the government put through last year or the year before.
Correct. Some of them are tweaks.
So they've had it for a year and gone, the union movement doesn't like that, we'll change it again.
If there is a theme to any of this, it's that we are on a journey.
And
this is just one stop in the journey, and there are many stops.
Many stops. This is roughly what I want to get through if we can today. We're going to do time frame. I have to talk about the Fair Work Commission because, believe it or not, the legislation is not the end of it. We put right to disconnect up front, and for the people who've sent about 70 questions through already on right to disconnect, thanks for that. And then we'll follow through casuals, new definition of employment, wage theft, and then we'll pick up some of the other stuff as we sort of get down the back. Timing. Now you wrote this slide, so let me perhaps interrogate you because it's not very easy to read. Has everything started today?
It definitely has not.
Right.
There are limited things that have started today, as you'd expect, because people can't click their fingers and change the world. I think maybe just starting with today, if you are in a intractable bargaining situation.
There's about 4 people in the country.
Exactly. If you are at the end of you are at the very pointy end of industrial relations and you've got an intractable bargaining situation, there are certain things that have come into place now, which we'll talk about, which you will probably have already been advised on. They're the people who really need to know that all of this starts today. 6 months is the time frame I want to convey today. 6 months is, the clock is ticking on a 6-month period, which is 27 August 2024.
So all the casual changes.
Casual changes, definition of employment changes.
Right to disconnect.
Right to disconnect for non-small businesses.
So non-small businesses 27 August?
Yep.
Small businesses?
Another year
after that.
On top of that. So we'll probably we'll have read about 1 million op-eds about the right to disconnect before small business get it. But we've got 6 months. Employment industrial lawyers, HR advisors who are listening, you've got 6 months to get those things in order. You'll see on the slide there are some other various dates along the way. You'll see one of the first column's actually in the past, and so hopefully this isn't news for people. Positive duty to eliminate sexual harassment, Human Rights Commission powers and so forth, but yeah, it's all happening.
So if the viewer really wants to get into the timetable, they just focus on this slide, they'll be fine.
Exactly, and you can find it on youtube.com
after
afterwards. Today.
Excellent, well done. Look, as if all of the changes in the legislation wasn't enough, I just have to indicate that a lot of the changes require the Fair Work Commission to now put stuff in modern awards. That's all going on as we speak. It started over a year ago, but it's gaining momentum even further now. It'll carry through this year. I've put up on the left-hand side all the sorts of things that are being looked at. Probably some of the bigger cases will be job security, delegates' rights, I suspect gender undervaluation, which will be happening in the middle of the year. That'll be a big issue coming through that possibly could dramatically lift some minimum wages in modern awards. So there's a lot happening in that space. And if you were worried about the legislation, just be conscious that the union movement generally has said, thanks for the legislation. We actually want to try and get more when we make these changes to the modern awards. And we're involved in all those matters, and we'll be doing our best to defend them as best we can.
Yeah, and in fairness, look, employers are making claims in those various test cases as well. But it very much is a sense of, well, the baseline, as it always is the NES and the Act, and those cases you would suspect will consider how to take things further.
So in relation to a number of topics we'll talk about today, not all of them, but some of them, there'll actually be a continuation of, as you put it, the journey.
Yep.
All the way through this year in the modern award system. which will have direct impact for people employing people on modern wards and possibly indirect impact for people on enterprise agreements. And for some of these matters, they actually end up as being default provisions for enterprise agreements, like the Delegates' Rights Clause. But we'll do more on this through alerts and everything as it develops. I had to start here. It was the only place to start.
It's the
hot
topic.
It's the hot topic. And what I want to first of all do is I want to say what it's not, because we've had a lot of gumph out there in the media. And a lot of people are saying, I'm no longer allowed to send an email or a text message to an employee outside work hours.
And I'll be jailed if I do.
That's wrong. That's just wrong. You can still send the email, you can still send the text message. Try and avoid harassing people with them. Don't send 100, but that's a slightly different topic. But you can still send. Some people are saying I can no longer call an employee outside normal work hours. That's wrong. You can still make the phone call, that's fine. And still some people, because it was in the original draft, are saying if I do all of these things I could go to jail, it's a criminal offence. That's wrong as well. So just understand there's a lot of emotion out there about this topic. It's not those things. So let's talk about what it is. It's effectively, and this is a phrase I've used, we've been talking about this, it's effectively a right in certain circumstances for your employees to ignore the email, the phone call or whatever, or as the legislation talks about, the right to refuse the contact. It's not aimed at stopping you initiating the email, the phone call in the first place. And in simple terms, it allows employees outside of their working hours, that could be their ordinary working hours, could be their overtime hours, reasonable additional hours, to refuse to monitor, read or respond to contact or attempted contact from their employer. And you can think about that covering emails, WhatsApp, text messages, phone calls, the works. Importantly, the right extends to third parties. So that also involves situations where a client or a customer might be trying to contact one of your employees. The right extends to that as well. And I think very importantly, it doesn't, as I said, stop or prevent the employer or the third party attempting to initiate the contact in the first place. Now, the big test is that right to ignore, that right to refuse, cannot be exercised if the refusal is
unreasonable.
Unreasonable. It's a lovely phrase, unreasonable. I thought we'd define it. To be unreasonable is not guided or based on good sense beyond the limits of acceptability or fairness. It's interesting in the sense of it's different to reasonable. It's actually a much higher bar of it's actually gone so far it's unreasonable to do it. But most people, I think, if they keep that definition in mind, they'll decide whether or not what they're doing, why they're doing it, when they're doing it will constitute that. The legislation gives us some really good guidance. We've set up there on the slide the circumstances that will be taken into account in considering whether or not something's unreasonable. And they're perhaps not particularly surprising when you have a look at them. The first one is the reason for the contact. Obviously, sometimes the reason might be life-threatening, it might be important, it might be business critical, other times it might be particularly of no moment. How the contact or attempted contact is made and the level of disruption the contact or attempted contact causes the employee, a very natural thing to take into account. The extent to which the employee is compensated. So if you're on some whopping salary, no doubt you're expecting to be bothered over the weekend and late at night, very differently to the person who's on minimum award wage sitting in the factory.
You might be receiving an on-call allowance as well.
Could be that as well. That would be a very good example of it as well. The nature of the employee's role and the employee's level of responsibility, and that gets into that sort of seniority or whether or not the role is actually focused on the need for those types of contacts, like sales reps and things like that. And the employee's personal circumstances, that is perhaps why the employee elected to ignore in the first place. And most people will kind of see that that's really, as we've described it, contextual. It's very much how, when, why, who. and probably be considered on a sort of a case-by-case basis.
Again, Nigel, though, the test of unreasonableness, it's on the refusal. So you're not applying that matrix to
why you're sending it.
Exactly.
No.
You're applying it to whether the refusal, or as you say, the decision to ignore was an unreasonable one or not. So when you think about that, as the employer, it's not as if every time you pick up the phone or sending the email, you're necessarily going on through these, is the employee at a family birthday party or something?
The question would be, if the employee ignores you and you actually needed them to get back to you, is what they've done unreasonable?
Which is a much smaller set of circumstances, I would think.
Yeah, and that you're right, the focus is on the employee and the ignoring.
Exactly.
It's not on the initiating by the employer or the customer or whatever. Now, in practice, you might disagree with me. We'll wait and see. We'll have a quick chat. I think that in relation to most executive positions, I don't think this will be an issue. I think well paid, there's a general understanding of when out-of-hours communication is required. I think if you're working with a good management team, I don't think this will be an issue. I don't see the CFO of a large company tomorrow turning their phone off at 5 o'clock on Friday afternoon and refusing to take a call from the chairperson or the CEO of the company. So I'm not really stressed about executives, to be honest. Managers, well, that's an interesting issue, particularly if we're talking about low-level managers, supervisors. Then I think, sometimes they do get hounded a little bit. And it might be, again, in some of their contexts, it might be, is the decision to ignore an unreasonable decision?
I go back to, they may be hounded, but are they ignoring? And then why? And then once they ignore, is the employer or the person who's sending them the message following it up and seeking to enforce the fact that they should have picked up the call? I think there's a pretty small subset of cases.
I agree with that too. I think it is a small subset of cases indeed. Look, customer-facing sales reps, there might be a little bit of play around here. There's probably a general expectation that customers will ring you. I mean, we expect clients to ring us after hours.
Yep.
So I think, again, that'll be in that context of the responsibility and the role. But if you've got a customer who's badgering a young, lowly paid sales rep at 3 o'clock in the morning on a Friday night, more than likely it's reasonable for them to ignore that call, unless it's the critical contract that they've been waiting for the last 3 months. Again, all context.
It's possible. And again, the question will be, as the employer, are you going to bring the hammer down, so to speak, on
to challenge that issue?
Exactly.
To challenge that issue. And then we've got blue collar. And I actually think that blue collar is probably not where the problem is. It's where you need to think carefully about what you do and don't do about after hours communication. We said three things. If you're expecting too much of lesser paid managers or customer facing people, that might ring an issue. Could it be used in an industrial dispute? I might make some comments on that before we leave the topic. And I suspect the truth is that it's just another issue that might get added to the list for the disgruntled employee, along with all their other reasons why you're not a very good employer. I suspect that's true. You've got a very strong view about the last one.
Well, I mean, yes. The reality is if when an employee disengages, this will provide another tool to disengage. And
to create a point of tension with the employee.
To create a point of tension, to create a point of dispute, and potentially to create a legal avenue for an industrial case, which then creates another burden. So it's definitely another tool for someone who has become disengaged to use.
And look, I don't want to go into too much detail other than to say a couple of things about process. This is a right. It can ground adverse action general protections provisions in the legislation. So if you actually try and enforce your right to communicate, let's say you issue somebody with a warning, and the circumstances of their refusal to contact you are not unreasonable, it could ground an adverse action claim. So you need to have some sensitivity around that, particularly as you said, if you're dealing with a disgruntled employee.
I just might stop there. I can see this happening in a performance management context where someone's performance isn't where you want it to be, but part of that performance issue is their failure to respond to emails or to get back to clients or to be timely in doing certain things. I can see the right to disconnect being sort of referenced in a claim like that. And that's where it's useful for an employee perspective that it's an adverse action general protections right or workplace right, because you can say, well, yes, I didn't do those things that you required me to do, but I had a right not to.
Yeah. I had a right not to review the email.
Exactly.
Would be a good example. Ultimately, the way the system will work is if there is a dispute, it will go back to the Fair Work Commission. The Fair Work Commission's got relatively broad powers to tell you to do things, tell you to stop doing things. The one thing the Fair Work Commission can't do, it can't issue compensation. So this is very much like the bullying jurisdiction and a variety of other more contemporary jurisdictions which have emerged with the Fair Work Commission, where the Fair Work Commission can intercede and try and create a regime for working going forward, but the answer isn't, here's a cheque, off you go. So the Fair Work Commission can get heavily involved. We understand that there's going to be a bit of a test case at some time this year, because there'll be a right to disconnect provision going into modern awards, and we'll obviously have to see whether or not it maintains the scheme of the legislation or whether or not it changes. My money will be on it'll maintain the scheme of the legislation. It's too young a concept to get carried away with.
Correct.
I think that, so I don't think we want people to panic about that. What I want people to do, I've got a long list here, perhaps I can talk about the one that's probably the most important. I'd probably do number one. This is the one that really intrigues me the most. I've been saying this to people now for the last 2 weeks. Think of the forms of outside working hours communication you currently use. And, ask yourself, if I use that form of communication and one of my employees said, I'm going to exercise my right to ignore you, is their conduct unreasonable? Now, I reckon for 99.9% of times you contact people out of hours, there shouldn't be an issue. The ones that I'm particularly interested in are the ones that relate largely to, say, blue-collar workers. So think of situations where you get the employee to ring a contact number to get their start time for tomorrow. Think of the situations where you text the employee 2 hours beforehand about their start time. The rail industry would be a good example of that. Some of the disability services sector would be a good example of that. Think about how you run your on-call roster.
Yep.
The on-call roster is a classic one. If you've got one of those on-call rosters where through industrial perhaps pressure over the years, you can't call the second person on the roster until you've spoken to the first person, and the first person decides not to actually come back to you, you're going to get stuck. So I would just say, don't panic, but just identify where you normally communicate outside work hours and sit down and do a bit of an analysis on the risk of that. And if you've got some in the risk category, I'd say give us a call and we'll talk to you about whether or not we think they are and what you might do to deal with them. There's a good education piece, I think, in this. And probably the bottom one's important. If you are a large company and you think this might become an issue, particularly say white-collar tech or something like that.
Yeah, I'm really interested in how white-collar part-time workers engage with this, because in some workflows, particularly in corporate environments, it actually depends on calling the part-timer on their day off to say, where did this get up to, or what should I do, or this email's come in about this thing, what should I do now? You need to think about the right disconnect for those people, because they may well ignore your call now, and the question whether it's reasonable or not is unreasonable or not.
That brings you back to number one.
Exactly.
It really does. And in some part it brings you to 6 as well, which is if you find yourself a situation where there is an internal dispute about this, what's the internal procedure to follow, rather than people racing off to the Fair Work Commission as the alternative?
Hot take number one, the Fair Work Commission is not going to have a huge jurisdiction in doing stop email orders or stop right to disconnect matters. You would think this would be used even less than the bullying jurisdiction, which is relatively seldomly used.
Well, and as you and I often say, because there isn't any money in it, I don't think the legal profession...
I think that, Nigel. I don't say it. Cynical.
We had I'll do a couple of very quick questions. A couple of quick questions came in, but does it impact my ability to ask somebody to work additional hours? No, it doesn't. Additional hours is an entirely different concept. And just be conscious that the notion of the right to disconnect is about contact outside working hours, which would include ordinary time, overtime, shift work, the list goes on. So just be very conscious about that. Will it increase potential adverse action claims? Well, you have a sense it will, but perhaps not dramatically.
Yeah.
I don't think it dramatically will. I don't see that being too much problem. Does the right cut both ways? So that's a really good question. I love that question. So we're thinking about the manager contacting the employee. What about the employee contacting the manager? The answer is it cuts both ways. Now, I would think that if an employee is ringing a manager, in most circumstances, that manager understands why they're ringing. They know that they've probably been paid to take the call. Their contract probably identifies all of that, and the manager will take the call. If it's an employee pestering a manager for something the manager thinks is relatively inconsequential, well, I imagine that manager probably is already exercising their right to disconnect.
Correct, and to be honest, no one's going to say boo when the manager does that.
Exactly.
So,
yeah.
yes.
Yeah, and number 5 is important, which is just respect employees for reasonable privacy. I am notoriously bad, Jules, to smile when I say this. I often fire off emails on Sunday. I get myself all fired up for the week. I'm very particular about saying to the staff when I fire off emails on Sunday, I'll talk to you about this on Tuesday, I'll talk to you about this on Monday. In other words, I'm not expecting you to read it, it's just I'm getting all of this out of my system now.
One interesting thing about working from home and the new post-COVID era is, and the right to disconnect, is that it's not apparent now when someone's working from home that they are necessarily working or that they're off sick or maybe they're on annual leave. So managers increasingly will call people's mobiles and say, need to do this task, and the person will say, I'm actually on annual leave. It's an interesting little thing for the right to disconnect, because I imagine a lot of employees, or they'll be entitled to simply ignore the call when they're on leave. I think they could already do that anyway.
I think they could. I think they could anyway. I thought you were dangerously going to the concept that people working from home actually weren't working.
No, I was not going.
You're not going to go there. You're not going to go there. So look, I want you to focus on it. The world hasn't fallen in. It's not stopping you contacting people. It's just creating a right in a relatively limited set of circumstances for somebody to potentially ignore the attempted contact or the contact. And then the question is whether or not they're ignoring it is itself unreasonable, and that's when the challenge will come. And if you do anything about this, just do number 1 and have a really good think through, when do you normally contact people after hours? And on the spectrum, if somebody says no, could there be a circumstance where it could be unreasonable? Or when they say no, is it always going to be a reasonable no? Particularly where I've said things like on-call rosters, allocation of shifts. I think most of those are okay on their face, but it would be worthwhile going through. I suspect we'll come back in about 6 months' time and do a whole one on this, because I suspect we'll have learned a lot more by then. Casuals. Now, the world's fallen in, but it hasn't fallen in. We're back to the future. We've gone back to the past. I think the first thing that should be said, I'll let Jules do most of this, but I think the first thing we had a few years ago now, we had this famous case in the High Court called Rosato. The High Court were getting very fed up with this idea that I could employ you as a casual, but you could kind of morph into something other than a casual. High Court said, no, we need greater precision than that. Let's focus on the terms of the contract. The then government amended the legislation to make it very clear it was about the terms of the contract. And this government doesn't like that. And so it changed, but it's kind of an interesting formula, Jules, isn't it?
It really is. And the loophole that is being closed in all of this, yes, it's to overturn the High Court's decision, which
I think the phrase loophole is propaganda, mate.
The loophole, well, it's important propaganda in this respect. The loophole that's being closed on this is the Rosato loophole, and I'm not doing air quotes because I'm just not going to do that, is the idea that you can be a casual, a very long-term casual and a very regular casual, and no one can do anything about it. If the contract says you're a casual. This changes that position, and we go back to a scenario where an employee will be a casual employee if the employment relationship is characterised by an absence of a firm advance commitment to continuing indefinite work. The employee would be entitled to a casual loading. And the point is the consideration is on the real substance and the practical reality of the employment relationship, not just what the contract says.
Now, that's a great new definition, which kind of is just winding the clock back, isn't it, in a way?
It is, and to be fair to the High Court, I mean, the High Court were looking for that very thing, but in the terms of the contract. The High Court did not want to do this exercise in synthesis of, well, let's work out where this person who was a casual might have become a permanent employment. The High Court were interested in what are the rights and obligations of the employee and the employer. Where do we find rights and obligations? Let's go to the written contract. Oh, they're there. What does it say? Well, it says they are a casual, it says they get a loading, and so on and so forth.
The immediate panic of the audience at this moment in time is something like this. Does that mean all the people I employ as casuals, because of these new laws, will be full-time employees in 6 months' time?
That is the question that everyone asks. And the great... We probably should go back to the slide. But the great part, the great part of this change is that does not happen. Let's go 2 slides ahead so we can have the magic. There is no more.
So I can't be light blue today.
There is no
and blacky grey tomorrow.
There is no click of the fingers. I'm a casual now and I'm a permanent employee. 4 seconds later. That's actually what the High Court didn't want to do. They didn't want that to be the state of the law, and it's not now either. So that's very good. What happens under the new casual employment definition is, with one important exception about the commencement, unless the casual actually chooses to become permanent, and unless they satisfy a series of tests to make that election, they're not going to convert to permanency. This is very important from a certainty perspective. You have legal certainty whether someone's a casual or whether they're a permanent employee. There is uncertainty involved. You've got what I call operational uncertainty. You don't know necessarily which casuals and when those casuals are going to choose to become permanent.
So what if I get it wrong right from the beginning?
If you get it wrong from the commencement, they're not a casual.
They're not a casual.
But they never would have been a casual even under the old law. You could have a sham contract saying they're a casual and they're actually not. You could have no contract and assert that they're a casual and they might not be. This will not protect you.
But if I'm a casual today working under an award or an enterprise agreement, I get a casual loading, I'm deemed to be a casual unless this change occurs.
Correct.
The trigger occurs.
Correct. Okay. With a decent casual contract that has.
Yeah. I can't because of these new laws say, well, I've kind of morphed into being something else. No. There's got to be the event. And the event is the casual conversion process.
Yes, it's a new choice process.
Right. Now, in the old days, we just go back, the old rules were at a certain point in time, the employer had to say to the casual, would you like, if you meet a criteria, would you like to become permanent?
In the old arrangements, there was an employer offer obligation and an employee election obligation as well. That is now gone. That is possibly the most popular part of all of this reform, the fact that the casual conversion process has been streamlined and essentially we just have this new choice process. We don't have the employer offer process anymore. I think we've got 6 more months of it because they need the systems need ships in the night. They need to go past each other. But yes, the new choice process is that the employee satisfies if the employee is no longer a casual employee and they choose to become a permanent employee, they can do that.
Now, I think we jumped the slide. I'm going to jump back quickly. These are some of the criteria.
Yep.
So if after the requisite period, 6 months in a larger business, 12 months in a smaller business, I'm a casual and I go, hang on a minute, I think I now meet the criteria for actually not being a casual, then that can trigger my right to say to my employer, I now wish to be an ongoing employee, which is, as you put it, the new casual conversion choice.
Correct. And if you go back to the previous slide, one thing that people are a tiny bit concerned about is how broad these criteria are. They are very, very broad, and many clients will say, well, I mean, if you look at the second dot point, yeah, of course it's going to be reasonably likely that there'll be future availability of continuing work. Or the third dot point, of course we have full-time and part-timers who do similar work to this casual. Yes, that's how the legislation's meant to work, in that if this employee who's a casual could be converted into permanent, they will have a choice. And then subject to the refusal slide, which we'll get to, they have a choice and they can elect to do so. It's meant to work like that. It's meant to make it easier for casuals to become permanents, because that's kind of the point.
So for most of our viewers, I've got a casual employee currently working under a modern award or an enterprise agreement, being paid a casual loading. I don't need to worry about them at this point in time.
Well, you don't need to worry that they've changed overnight.
They haven't changed. That's the point. They're still a casual. The question then will be, does the casual exercise this right to say, I shouldn't be a casual anymore, I should now become continuous?
Yep.
And that can be done, we said there, after 6 months in a larger business, 12 months in a smaller business. That's 6 months, 12 months of employment.
Yep.
And the employer's got 21 days to respond when the employee says, I think I should change.
Correct.
Now, on the left-hand side, we said if they accept, there's quite a bit to work out.
Of course there is.
Are they full-time?
Of course there's.
Are they part-time?
Of course there is, because they're going from a casual to permanent.
Exactly.
I mean, it makes sense of what you need to work out. And to be honest, this will be a challenge for a lot of employers to go from, okay, well, you're no longer a casual anymore. How do we get this to work?
How do we move you from being an orange to an apple?
Correct.
Yeah.
Correct.
Particularly when you were working slightly orangey hours and now you've got to work slightly apple hours.
Correct.
Which has all sorts of problems with it, because there's all sorts of rigours and strangulation around part-time hours, flexing up, flexing down. So it could be a real impediment for a lot of employers.
We don't want to get started on
part-time. Don't get started on part-time. Having spent years running those cases, that's true. But the employer can decline.
They can.
They can.
They can. So the grounds for declining are on the slide. The test, the multi-factor test, is the fair and reasonable operational grounds. Would substantial changes to the way that they're going to work be required if they're going from casual to permanency? Would it significantly impact the employer's enterprise? I think employees need to understand that the grounds for declining, the ability to decline, is more limited than it once was, because the tests are just broader for what is a casual employee or what is a permanent employee compared to a casual. So it's going to be harder to decline. That does not mean, however, that you'll see more employees choosing to become permanents, as we well know.
We're having run those cases.
Many employees, casual employees, do not want to be permanent employees.
No, well, particularly if you're talking about the student, be it a school student or a university student. The idea of having sick leave is irrelevant. It's just I want the casual loading, gives me a high headline rate. There's a vast array of sectors out there, the coffee shop, whatever. I don't think this will ever become a practical issue anyway.
Yep.
It's possibly more a case of what you might describe as the bigger operator, and we'll come to this, I think, in probably the next couple of slides. But clearly the right to refuse, and if there's a contest about refusal, where do we go?
Commission.
Fair Work Commission. We'll go to the Commission now.
Answer's always Commission.
Fair Work Commission. And the Commission's got the power to say yes or nay and sort it all out. Things to do.
Yeah, so I'm quite tickled by the new casual employment statement. You have to give it out a lot. So for non-small businesses, you have to give it out on commencement. You have to.
So first of all, there is a new one, isn't there?
Correct. On commencement, after 6 months, after 12 months, and every 12 months thereafter. I'm not making that up. That's the provision.
Well, it's really good that we don't lay a business up with administration, isn't it?
This is the what do you call them? This is the drawback, or this is the counterbalance to the casual conversion simplification. Is that yes, the casual conversion process is simplified, but you do need to continually tell employees about the casual conversion process. So that's one piece of admin that needs to be done.
Now, some of this doesn't apply to small business.
It doesn't. So small business don't need to do it after 6, because it wouldn't make sense, because you don't have an entitlement after 6, and they don't have that ongoing every 12-month obligation to provide the statement. Again, it's just providing a statement. It's not the biggest compliance cost in the world, but it's still there. Casual employment audits, I think that's there because, as I said before, this is going to result in operational uncertainty rather than actual legal uncertainty. If you have a whole suite of casuals who could potentially one day wake up and say, I want to become permanent, you need to understand.
Yeah, and a good example of that would be, I'm just thinking of clients now, we've got clients, for instance, who go, well, we fill the back shift with casuals.
Yep.
And we've always filled the back shift with casuals. And some of those casuals have been there for a very, very long period of time. they would be right for possibly making this change. That would be a good example. And I think you're right in the sense of, again, starting when? Not today.
6 months.
6 months.
Yep.
All this starts in 6 months' time. So you've got 6 months to kind of look at where you're using casuals. If they're genuine sort of university student rolling in, picking up the Thursday shift and whatever, I wouldn't be too stressed about it. If on the other hand you've got, as we say here, high proportions of regular casuals sort of pockmarked around your business, I'd be thinking about, well, is that an area which is going to cause me operational issues? And if so, how am I going to manage it going forward? We've already seen a number of our clients go, I'm not sure why I'm even doing that anyway. And they've started to make the change to increase full-time employment.
Yeah, well, they've tried to make that change, but the casual employees have said, no, I don't want to be a permanent employee.
I know, well, it's a challenge. And obviously making sure that you've got an internal understanding. If you do have somebody who says, I think I meet the criteria, I want to be changed, what's your internal process for managing that?
Exactly, and also understanding the transition between the offering of casual conversion and the new process where it's just if it's employee choice. There's a bit of admin to do there, but I think, as you say, Nigel, a lot of employers have sort of put their finger up in the breeze and worked out, well, maybe we should be trying to get away from casual employment unless we need to. You can try and do that. Whether the employees want to do it is another question.
So again, it's a big change, but the extent to which it really impacts, I suspect, will be somewhat more focused and isolated. I don't see this necessarily as a general change. I think one of the areas where people will need to think about is making sure that as they move forward, their employment contracts properly reflect this for casual employees.
Yep.
And as you say, there's a massive administrative burden on the casual employment statement.
There's ways you can fix that. I mean, there's ways that
you say that with great ease.
I mean, there's ways you can embed that in an email or embed that in some kind of periodic update to your casual employees. So I'm not massively stressed about that.
I've got no doubt if you're a very large company, the answer is yes. But if you're a middle-sized company, I suspect that's going to be one more administrative task you don't need. There's
literally hundreds of tasks that we're assigning people based on this legislation, so that's fine.
It's just one more.
Exactly.
Just one more. Now, they love changing definitions. So now, I don't want to panic people, but the definition of employment's changed.
Yeah, it seems pretty fundamental, doesn't it?
It seems fairly fundamental. Again, High Court decision in personnel contracting. There was another case at the same time. I always call it JAMSEC, but
I've been told it's Jameshk.
Jameshk, yeah, I'm not pronouncing it correctly. This effectively overturns personnel contracting. I'm a little less sure it overturns everything that was said in Jameshk, and I'll talk about that quickly before we finish today. Do you want to lead us through?
Yeah, look, again, it's overturning the High Court's preference for elevating the contract to the status of king or queen. So this change in the law means that you cannot just write in a contract.
You're a contractor.
Someone's an employee or someone's a contractor, and that be so. You need to look at the totality of the relationship between the individual and the hirer or the engager. It's not just the terms of the contract, but it's everything else. And we're going back to a scenario where you're looking at the real substance, you're looking at the multifactorial test, you're starting to talk about if it walks like a duck and quacks like a duck, it's a duck. So that's where we get to. Interestingly enough, you're going to have to look at how the contract is actually performed. So the High Court really didn't want to do that in those cases. That's not a criticism, but as I said before, the High Court's position was if you want to know what the rights and obligations are, you look at the contract. Now it's not just that, it's well, how does the work
So before
get
personnel
done?
Contracting, somebody would ring us up and say, is this person really a contractor? And we'd say, show me their contract. And then we give them a long list of things and say, in practice, how do all these things happen?
Yep.
And we sort of juggle all that together and we go, more likely than not, they're A or B.
Huge amount of uncertainty.
We normally make a call. High Court comes along and says, don't like that. It's all about what you wrote in the contract.
More or less.
Let's be careful. I'm ad-libbing a little bit with that one, but effectively, and now we're kind of back to where we were before.
Correct. And the reason that we're back to where we were before is, again, this dislike for the position that an employer or a hirer could
just write a document.
Exactly.
Yeah, okay. Now, there's a weird bit to this, which is the opt-out notice.
There's two weird bits. There's two weird bits. And I'll do the fundamental and really kind of important weird bit first. This is not like casuals in that in the casual scenario, we talked about there's no magic clicking of fingers, you become casual to permanent. In this one, it could well be the case that after you do the assessment, someone has morphed from a contractor to an employee. That could be the case because there's no contractor choice or no employee choice except for high income contractors. So
which isn't defined yet.
No, we haven't got a high income threshold for contractors yet. But if you're a contractor who is over the high income threshold, you could opt out and say, no, I actually don't want to be on.
Even though I might technically be an employee, I don't want to be considered one. Thank you very much.
And there's all kinds of reasons why people might do that. Tax.
There's also tax.
It's always tax.
It's always tax.
So that's very limited in terms of the subset, or maybe not the subset of people that this will apply to, but the way this works is there is uncertainty, legal uncertainty for contractors being employees now, because it will be not enough to just rely on the terms of the contract.
And probably the one thing I do want to say is that we work very closely with clients on these types of issues all the time. I'm not immediately stressed about this, generally speaking, and probably the one area that we spend a lot of time with clients is with owner drivers, lorry owner drivers. I don't want people to be panicked about that. I think that if you've got somebody buying a $100,000 truck, be they a sole trader or an incorporated entity, I don't want people to stress about that. I don't think there's too much of a challenge there. I think those will be, they're contractors, they remain contractors. So I don't want people to be panicked about that straight away, because I think that's very much at the back end of the problem queue in relation to this issue. I think the greater issue with these will be the famous ones which are popping up all over the place at the moment in this country, and that is Bob turning up with an ABN and pretending to be a contractor. And I've actually started to see that happen in a lot of places, which bothers me a great deal.
Yeah, it's interesting. I mean, it's also worth saying that that this change doesn't radically change what a contractor was understood legally to be. It's not restricting the scope of contractors and then broadening the scope of employees. There's other ways that this Act does that, but it's not actually doing that. So unless you've radically and probably inappropriately changed your contracting methods post personnel contracting and Jamesh, I can't see it being a massive issue.
You're absolutely right. If after personnel contracting you took 30 genuine employees and said, here's a contract that says you're a contractor, you're probably in some trouble.
There's an argument, and the High Court would say, let's verbal the High Court would say you're in trouble anyway because they're probably sham contracts anyway.
Probably sham contracts. So I'm with you. It's a change that we have to take into account, but it's not one of those that immediately has changed our world from an operational perspective. Yep. I agree with that. I think we just said that.
We did. Let me just unpack the red flag for 4 seconds. If you've got contractors who are integrated in your business, this is potentially a problem for you because you can't rely as readily on the terms of the contract. If they kind of would have been employees under the old way.
Particularly if they're sole traders.
Exactly. If you've got really low skill contractors who are contractors in name and by contract.
Like my concept, Bob with the ABN.
100%, you've probably got a bit of an issue. And this idea of contract and reality misalignment. So if your contracts say things that does not reflect the practical reality, you need to accept the fact that you're not going to be able to rely on the contract in the same way as you did before. That would be a problem anyway.
It would be a problem anyway, and we see that when we redraft owner-driver contracts for people. They've taken some massive commercial contracts. There's no way the little owner-driver company, Bob Proprietary Limited, with Bob driving the truck, is ever going to be able to comply with half those terms. Yep. And they're not required to anyway.
Yep.
They're not required to anyway. So look, it's moving, but it's probably not something that probably has to be right at the forefront of people's minds.
Yeah, I mean, it remains a problem. Basically.
It remains a problem. Wage theft, a term I hate. It's a brilliant piece of neuro-linguistic programming and propaganda all rolled into one.
As I've said many times, the war is over.
The war is over, and we'll stop fighting it.
This is the term, and we will use it.
And we will use it because it's now the term. And I think the really important thing to say very simply is this. The notion of wage theft has now been identified as criminal.
Yep.
Now, immediately, most people might go, gosh, what does that really mean? It is quite a contained proposition. I don't want people panicked about this. Let's assume that you do underpay somebody, you don't pay them the award rate of pay properly. The question is, did that arise as a result of an intentional failure? So if it's inadvertent, if you've just misapplied something, the system's not properly worked, that's not going to be an intentional failure. So it's where you've intentionally decided not to pay somebody correctly. Now, originally when it first came out, it was just all about wages. And our lovely friends the Greens passed an amendment which went through, which now means it's pretty much the box and dice.
Yeah, it includes, I mean, most significantly includes super theft. Which is another excellent phrase.
Super theft, great phrase.
But, and I think probably there are issues with superannuation underpayments. Probably they exceed wage underpayments out there in the world.
Well, to be fair, as you and I worked on a matter very recent for a client, it is so complicated sometimes.
Yes.
It is so complicated. But bottom line is that it's not just about wages, awards, enterprise agreements. It does cover super, long service leave, jury or paid emergency service leave, which was originally out, but our lovely friends with the Greens Party decided that should come in. And I think the government said, oh, well, if you want that, we'll give it to you. And that's in as well now. I'm only saying slightly cynical.
Just going to continue to look
slightly cynical about this. Now, what are the penalties? Well, if you're an individual, you can be fined or you can go to jail. I appreciate that most viewers will look at that jail term of no more than 10 years as an extraordinary proposition. There are a whole raft of very serious crimes in this country you don't get anywhere near that for. I don't want people to panic by that because the likelihood of that actually happening, I think, is quite remote. But clearly the penalties are very, very large.
Yes.
Very large, and we're talking about potentially up to over $1 million for an individual. And certainly for a body corporate, we're talking about very, very, very large fines indeed. Probably three things we want to say. The Director of Public Prosecutions or the Federal Police are the only people who can commence a criminal proceeding. I've had a lot of people ring me out saying, can a union commence a criminal proceeding? They cannot. I suspect the DPP will act most likely on some report from the Fair Work Ombudsman or something like that. Just be very mindful about what deliberate really, really means, because it means I intended to do it. I'm aware of what I'm doing and I intend to do it. And I would say for most people out there, and we've been doing this now for 3, 4, 5 years with clients, if you've got any concerns about whether or not you're paying people correctly, do and then periodically do a risk-based audit. You don't have to necessarily review absolutely everybody. We tend to take a triage approach, look at particular areas or topics with clients where there might be increased likelihood of risk, or we look at particular, we might take 4 out of every 40 people and have a look at those. But it is a very smart thing, I would say, particularly if you're a publicly listed business, because the reputational damage around this is profound.
It's radioactive.
It's radioactive, yep. Absolutely right. And, there isn't a month goes by now where we're not doing some kind of payroll audit review for a client somewhere. So it's something to make sure you stay ahead of. If you happen to be sitting in a room one day and somebody says, let's not pay them that even though they're entitled to it, please speak up, because then you're moving into the world of deliberate action. Union powers and delegates. I'm going to move through this pretty quickly if we can, Jules. There is now some increased change to union right of entry into premises. This actually is not a dramatically new law in Australia. It's quite a new law federally, but it's actually been a law in some of the state systems for quite a long time. A union can actually get what's called an exemption certificate to enter an employer's premises without notice, where a union is seeking to investigate underpayment of wages. That's been available in jurisdictions like the New South Wales industrial system for a great many years. I think from memory about 3 of these certificates have ever been issued. Obviously this might be more of an issue if you're living in a world where it becomes a union tactic. But for most people, just be aware that that is there now. I don't think for most people it'll cause particular grief. What is perhaps more relevant is that we now have enshrined in the statute for the first time a series of rights that union delegates are the beneficiaries of. Just very quickly, can I just say this? Don't get confused between a delegate and a union official. The delegate is your employee who happens to be elected or authorised to be the union's delegate on the site. It's not, these rights aren't about the union official. Very importantly, it doesn't turn the delegate into a union official with the union official's rights. And very importantly, the legislation does not mean that you have to have a union delegate. We had a lot of businesses ring us up who have no union presence at all who said, does this law mean I have to now invite the union in and have a delegate? The answer is no.
I mean, the point of the law is to get more union delegates, though.
Well, and I suspect to get more union membership. But the bottom line is that this is not about you having to invite the union in and having to have a delegate. So please don't. A lot of people rang up about that last week and were quite concerned about it. What are those rights? Well, those rights are essentially that the delegate has to be recognised. The delegate is given certain rights to represent people in their industrial interests. That can be members of the union in your workplace. It also can be people who are eligible to be members. If you don't understand what eligible means, I won't deal with it today, it's complicated. But give me a call or give Jules a call, we can have to talk to you about what eligibility means, because it's all about how unions' rules are written, which is quite an interesting but complex tapestry to get into. The delegate will also have the right to reasonably communicate with the union's members or other persons, and for the purpose of representing them, reasonable access to the workplace and workplace facilities, which could include the photocopier, could include a phone, possibly could include a computer, and they have a right to paid training. I'm going to call it trade union training, although that's an interesting proposition. This does not apply to small business. This particular right, it's only applying to people other than small business. And so these rights are there. They start in 6 months, isn't it?
Yeah.
I think it's 6 months. We'll come back. We'll double check that.
Yeah,
I
need to go back to the slide.
I think 6 months. And just be very conscious that the Fair Work Commission is currently in the process of holding a proceeding to include in every modern award a workplace delegates' rights clause. And you and I are writing those submissions this week as we speak.
Yeah, and I think that's probably, I should be careful what I say. I mean, it's certainly a test case that the Fair Work Commission will run, which will then, they'll need to think quite deeply about what goes into modern awards on this topic. And
particularly because even though some of these rights have historically been in enterprise agreements and in state systems, in state awards, this is the first time in the federal jurisdiction that these rights have been enshrined in federal legislation. And very importantly, these rights now represent a workplace right.
Yep.
And a workplace right is able to be actioned on the basis of adverse action and general protections. So again, there's another avenue where somebody might seek redress if you have not allowed somebody who is an authorised delegate to actually exercise these rights. You'll notice all the way through the slide the word reasonable is in there. The legislation sets out all sorts of criteria about reasonableness. I won't go into them today, they're quite lengthy, but it talks about the size of your business, the types of facilities you have. So a lot of these questions about what's reasonable ability to communicate, what's reasonable access to facilities, all of that is going to be contextual rather than written in black and white rules.
Well, you could have an enterprise agreement or something like that says how, I mean, because what people want to know is how much paid leave do these people get to do union training?
The test case might find that out.
Exactly, and I think that's the question that we see a lot of, and that's probably the real tension, because I see delegates' rights. If you have an active union participation in your business.
Like this is a non-issue.
If you've got workplace delegates already, it's likely that this is all.
You've probably got clauses all over your enterprise agreement, my choice. Now, the big ticket item is not just that there'll be a test case. The big ticket item is that after 1 July, when you make an enterprise agreement, you must have a delegates' rights clause in it. If your delegates' rights clause is less favourable than a delegates' rights clause that's in a modern award that covers your employees, that clause will apply. And just be very conscious of this, even if there is no union party to your enterprise agreement, you still have to have a delegates' rights clause. So for those people with non-union agreements, it's not just you'll have to put this in, you'll have to explain to your employees why.
Well, it's a very leading question. It's a conversation that leads somewhere, probably to having a delegate, probably to having a more active union participation in your business, and all the things that brings.
Now we started late today. We're just going to probably pick the pace up now we've got through those. Gig. Let's just say a few things about gig. The Fair Work Commission now has the power to actually create minimum conditions for people operating on the service platforms. Is that a simple way of putting it, Jules? You happy with that?
Broadly, I mean, the real question about this, cutting to the chase of it, obviously there are gig platforms out there, gig providers. Everyone knows who they are, and clearly this is going to apply to them. My interest is how broadly this jurisdiction will go to other types of organisations that operate off digital labour platforms, where they're not your obvious gig platform. It's not your obvious gig workers. That's the interesting part for me.
No, it really is. And you think about it, this notion of digital labour platform operator, it's a fairly broad definition. There's actually quite a few platforms, including platforms for tradespeople and things like that, which aren't probably the ones we're thinking of today. We're probably thinking about the person who delivers your hamburger tonight.
Yep.
But you're absolutely right. I use the word gig, but they're performing service contracts, so they're contractors in their own right. But digital labour platform operators, and there's a variety of criteria that we've put up on the screen there. We'll do more on this in due course, I think, because it probably needs a bit of a deep dive once it gets going.
Yeah, and look, the two sort of main forums of interest in this are the minimum standards orders, and obviously they need to be made before we can say anything intelligent about them. And then the second thing is basically the new unfair deactivation jurisdiction.
So in terms of the minimum standard orders that Jules is talking about, the Fair Work Commission can do one of two things when it looks at these sorts of people. It can create non-binding minimum standards guidelines, that is, here's a guide for what you should do, or it can actually create an enforceable order. On the left-hand side, we've identified the things that can be in those orders, and on the right-hand side, we've identified the things that cannot be. Probably the critical one for the yes is the one right down the bottom in my view, which is cost recovery.
Yep.
That is, if I'm providing the motorbike and I'm providing the labour, how do you ensure that for a given hour I recover costs? That'll be a fascinating case to be involved in. You and I'll grab that if you can, because what if I'm on 3 platforms at the same time?
I mean, there are very interesting consequences to all of this, as to particularly some forms of gig work, whether they're sustainable, put up against a minimum standards order. Like, we'll just have to see how that goes.
And I suspect there'll be some fascinating cost recovery modelling, which is very similar to the modelling we do with owner drivers in a different jurisdiction. And as you said, 2 interesting things. You can actually now make these collective agreements and have the Fair Work Commission effectively register them for these types of workers.
Yep.
And the other one is, if you are deactivated off the platform, you can effectively apply to the Fair Work Commission to be reactivated, which is an important thing. It's a fair go all round test. You can the remedies include reactivation and lost pay, but you can't get compensation.
The references to the algorithm will be very interesting in this case, because there's all kind of weird and wonderful things that happen to the algorithm when people are deactivated, or when people are sort of, their availability or their ability to get work is lessened. So again, pretty niche topic, but we'll
bring something back. I think we'll bring something back on that. Same job, same pay.
Yep.
Look, I'm going to do this fairly quickly if we can. This was originally a proposition which said if Company A has an enterprise agreement and company B is providing them labour. However, the original draft basically said that you can't pay, company B can't pay its employees less than the rates in company A's enterprise agreement. Massive media campaign. You would have seen all the adverts on TV about all this, which were not entirely correct in what they were alleging, but they worked. They worked. And for the most part, what we've now really got is it's about labour hire. For the most part, I think that would be a reasonable way of putting it. And that is if you are engaging a labour hire provider and they're coming into your business and you have an enterprise agreement covering the work they're doing, it's not that you have to pay the labour hire people the same, it's that there could be an application for an order, which is, as you see there, regulated labour hire arrangement order, for them to be paid the same money. So this is now on application, and it's really focused predominantly on the provision of labour, not the provision of genuinely contracted services. So you if you're in the left-hand box, I think you should be fine. If you use labour hire to meet shifts in demand, sporadic, probably going to be fine. If you're using labour hire as a kind of secondary workforce almost, and you've got an enterprise agreement.
Well, this is the loophole.
This is the loophole.
That's the loophole.
That's the loophole.
To be closed.
That's the loophole. Don't be shocked by that. You see, sometimes you see people who've outsourced large parts of their business to labour hire companies. I suspect they're the ones who are going to be under the gun.
And the point is, you're not going to be shocked because you already have the enterprise agreement, you already have the secondary workforce. The union have probably been furious about the secondary workforce. You know this is coming in, the application comes in, there's a case run, and then the order is made. So none of this comes as a surprise. This is another example of where this legislation, it's not a magical click your fingers, we have to pay these people the same as someone else,
it's an application.
Which could have been in the ads. Could have been in the ads. It's something very different to that. You know this is coming. I think there's some interesting questions, some grey areas between those boxes, where there'll be some interesting cases on this. And, as ever, we'll keep you informed.
We will. But I think the proposition is, and we've been working with clients very close on this now for over a year, I think people who are in that genuine contracted service box should rest considerably easier than they did before.
It could be much worse.
It could have been much worse. And for the people who are using labour hire as a core part of their workforce and who have an enterprise agreement covering the work the labour hire are doing, pick the phone up and give us a call because you're the people who might be the subject of an early case.
Yep.
Road transport regime, and can I be shameless?
Oh, you always are.
I'm always shameless. I can be shameless. So, as the authors of the book, and it's you, me, and our deep friend Lewis Itzo, who wrote the book on owner drivers in Australia, we now have to update it.
It's fine. Bring it on.
Bring it on. Second edition. We were chided about the fact we'd have to write a second edition pretty quickly. So as we've been speaking to clients about this, the Fair Work Commission now has the powers to actually create a form of regulation for what we historically will call owner drivers. That is people who own a vehicle and drive it as contractors, be they sole traders, be they little mums and dad companies. People who are familiar with Chapter 6 in New South Wales, the Owner Driver and Forestry Contractor Act in Victoria, possibly those people who know a little bit about Chapter 10 in Queensland, although it hasn't actually come into operation yet. I'll answer a question on that in a minute. The Fair Work Commission's now got the powers to regulate effectively road transport contractors. It was coming. We knew it was coming. There's a variety of advisory groups and expert panels being established. They can make these minimum standard orders which will set potentially minimum rates per hour or whatever for engagement. Now there's some funky stuff about the operation of those, and that is it's a 2-year rule, isn't it, Jules?
That's correct. I mean, the broad theme I would put on all of this stuff is a lot of this is still to come. A lot of it is a wait and see, and probably with time, there are limits to how deeply we can go into all of this. But yes, there will be notice about the minimum standards orders and so forth.
And there's this massive issue about from the time you actually get the notice, somebody saying, I want a minimum standards order, you've got to wait 24 months before it becomes operative.
Correct.
So I don't want people to worry that this is sort of something that's going to play out in the next 2 or 3 months. It doesn't even start for 6 months.
So yeah, this is again, if there's any part of this where you go, let's see how this plays out, this is it.
And you've got heaps of time to come and have a chat to us as well. Now, importantly, two things that are really important. When it was first drafted, it actually made it very clear that the New South Wales and Victorian regime was sort of excised as being special and left alone. It's now silent on that.
Yeah.
So the extent to which this might ultimately override New South Wales or Victoria is now up for grabs. It had always intended to be available to override the Victorian owner-driver regime. So I just want people to be aware that we had said earlier that if you're in New South Wales, you're probably safe. That's not necessarily the case anymore, although I would imagine there will be an internecine war between the New South Wales TW and the federal TW if the federal TW try and overtake the New South Wales jurisdiction, because it is a very mature and well-established jurisdiction.
There's so much good content in that book.
So much good content in the book.
I mean, it would be a shame to pulp the whole thing, but yes, it's that interaction I think is interesting and perhaps not as simple as we once thought it would be.
And look, the question I got asked the other day by quite a few people was, will it be a disaster like the Road Safety Remuneration Tribunal was? And that was a tribunal that was established federally to kind of do this. It's now, 5 or 6 years ago now? That's time flies, doesn't it? Maybe 7 years ago now. It's been a while now. It's been more than that. That tribunal existed for about 18 months and then got thrown out. I'm going to sort of go out on a limb here and say I don't think it'll be an RSRT disaster. Justice Hatcher, President of the Fair Work Commission, was for a large part of his career the Chief and Legal Officer for the Transport Workers Union. Justice Hatcher is very au fait with the New South Wales Chapter 6 system. He really does understand owner-driver regulation. I would suggest that the Commission will move cautiously around this in a very considered way. I don't think it'll be the kind of train wreck that the RSRT was. I'm going to say it was a train wreck. We were there. It was a train wreck.
The one aspect of the legislation which some of this plays out is that there are long lead times for certain things, and there's long lead times before certain things come into play. I suspect that is been included on the past history where things were coming into play far too quickly. Huge explosions and blow-ups were happening in terms of it politically and in various, from all kinds of people.
Well, it wasn't the principals in the end who picketed Parliament House, it was the drivers themselves.
Precisely. So in that sense, it's meant to be more orderly, and it looks like it will be. So
yeah. I think the bottom line is this: if you play in this space, it's now become real. We've been telling you that for a while. We'll bring something back to you in more detail. If you haven't read our alert on this, do so, because it's actually very detailed. Our alert is on this. But I'm with Julian. This is slow burn at the moment. If you're still working through things in the New South Wales, Victorian jurisdictions or the Western Australian jurisdiction, please keep playing the game in front of you. Don't do anything to depart from that. If you're in unregulated states, then this is probably something that you're going to have to start thinking a little bit more about.
Yeah, I mean, I don't want to engage in understatement, but it's fair to say, I think, one, we're very interested in this,
yep.
And two, we're probably going to be involved in this.
Yes, that's a good way of putting it. Yep. Very good way of putting it. But it's become real.
Yep.
And then I'm going to finish on bargaining, which is where you started, just so we don't complain too much. I think we're running to time with the late start. There's been a big change in bargaining, but it probably will impact very, very, very few people directly. But it might have an ambient impact, particularly if you are involved in bargaining, in what I would call industrial bargaining. That is, you can't win a vote, the union control a vote, and it is a genuine industrial negotiation. And that change is all about arbitration. As most of our viewers would know, and they would have seen most of this slide before, the system a year ago now introduced the right to arbitration to resolve intractable bargaining disputes. This was effectively brought in as an alternative to the right to apply to terminate an agreement to resolve a bargaining dispute, that right having evaporated. And the simple rules when this was brought in were that you had to have been bargaining for at least 9 months after you commenced or the agreement expired, whichever was the later. So it's a fairly protracted period. You'd had to have tried to conciliate in the commission. It failed. And there's no reasonable prospects of reaching an agreement. I can then apply and say to the commission, look, we've agreed to 90% of it, but you're going to have to actually arbitrate and hear the other 10. And when it was originally written, that was a merits-based decision. And that merits-based decision may very well have said, well, Mr. Employer, Mrs. Employer, I'm going to agree with your proposition that the roster in the agreement should change, even though it's not particularly advantageous to the employees, but by the same token, I'm going to set the wages at A, B, C and D. And it could be a very balanced outcome. The Greens came along out of nowhere. I'm being cute when I say that because we know where it came from, particularly Union in Victoria. The Greens came along and said, oh, we don't like that. We want to change the way the arbitration occurs. We don't want it to be a merits-based arbitration as such. We now want a rule which effectively makes the arbitration one-sided. And I'm going to let you articulate the rule because I get hot under the collar every time I say it.
You surprise me. But basically, the change is instead of being able to go to an arbitration and where an end result will be worked out on the merits, employees will not be able to go backwards on a line-by-line assessment
term by term of the existing agreement.
Correct.
So just think about that. If you don't currently have an agreement and you find yourself in this, that's perhaps less of an issue. But if you do have an enterprise agreement and over the years you've conceded a lot into it, which is now restraining your business, and you find yourself in an intractable bargaining dispute, when the commission come to arbitrate it, term by term in your agreement, the employees can't be worse off. So, for instance, if you're desperate to change that shift roster in your agreement,
and you're having the fight about it, which is why it's gone on for 9 months, and which is why you can't agree. The end point will be this arbitration, but when you go to that end point, when you go to the arbitration, when you go to the final decision, you won't be able to go. The employees will not go backwards. You won't, and if it's binary, the employees will not be able to get that change that you're seeking.
Now, this won't impact many people, but it's there. I think this might also, particularly in heavy industrial negotiations, it might start to have an ambient effect about making unions feel stronger in their position, less inclined to agree to things unless you genuinely buy them out. I think that would be an answer. I'm not going to give up on this quite yet. I've got a few clever ideas about what might happen in an arbitration and how you might actually position yourself, even with the challenges of what we might now call one-sided arbitration, to create the best result. We're talking to a client about one of those as we speak at the moment. But just be conscious that a year ago the government brought in arbitration for a particular reason. We think in Victoria, various people decided they didn't like the rules. And so a year later, they've changed the rules to make them more friendly to the union movement.
Yes, I mean, employers previously saw arbitration as, well, we've got a stoush, but the commission will fix it and they'll come to the decision.
Yeah.
This binds the commission in a really significant way, as the commission cannot take employees backwards.
Well, I think we haven't got time for questions. We tried to deal with a lot of questions on the run today. We were very conscious of the questions as they came through. I'm sorry it was a little rushed. It's a lot to digest. Hopefully, particularly with the right to disconnect, people are comfortable with that. We will work out what to bring back in the coming months. And I suspect as some of these things evolve, we'll bring back more and more detail. We'll probably do a session on one or two of these specifically as the months go by. As always, if you need to give us a call to talk about this further, don't hesitate to give us a call, Julian or myself. It's been a pleasure having you. These are interesting times.
Don't panic.
Don't panic.
Be alert but not alarmed.
Yeah, and be very mindful, as we said right at the beginning, about the timetable for introduction. We've got time for a lot of these things to get our heads around them, for you to get your head around them a little further and to understand the practicality of some of these things in your business and to take advice as you need. So, Jules, thank you.
Thanks, Nigel.
It's been a pleasure, and we'll see you in a little while. Take care. Be well.